The greater business prestige and goodwill, the more vulnerable it is to illegal business people. As soon as the designs and logos for a reputable and well-known business product line are introduced to the market, products with similar or even identical designs, patterns, and logos appear immediately. We are pleased to introduce Mr. Nguyen, partner and IP attorney of KENFOX IP and Law Office, who is joining us today with nearly 20 years of experience in dealing with IP-related matters in Vietnam. We hope that our discussion will provide you with practical perspective on how to effectively protect your IPRs from potential infringement. First, please take a look at two typical IP infringement cases.
Engelhard Arzneimittel, a German company, is the owner of the PROSPAN trademark for pharmaceutical products in Class 5 under an international registration designating Vietnam. Their Vietnamese distributor is SOHACO, one of top 10 pharmaceutical companies in Vietnam. SOHACO detected that a Vietnamese company, named VINH and THANG Long JSC, commercialized a cough dietary supplement with a packaging similar to PROSPAN packaging. However, the trademark used by VINH and THANG Long JSC is PROSTIBAME. Therefore, Engelhard Arzneimittel and SOHACO approached our firm, KENFOX IP and Law Office, to seek our advice on how to effectively handle the case.
Kunming De Hun Pharmaceutical Company, Limited, or we call it briefly as De Hun, a Chinese company, is the owner of the high Xenial mark for the medicated shampoo in Class 5 in Vietnam. Their Vietnamese distributor is Dong A Pharmaceutical Company, Limited. De Hun's distributor detected that a Vietnamese company named VINH JSC commercialized a shampoo product with similar packaging. However, the trademark used by VINH JSC is high nozzle. Therefore, De Hun and its Vietnamese distributor Dong A approached KENFOX IP and Law Office to seek our advice on how to effectively handle the case.
What are challenges of these cases?
I think that the first difficulty in this case is that although our clients' trademark have registered in Vietnam, it's impossible for them to rely on the trademark to enforce against the less infringement, because you know that the size high nozzle is not confusingly similar to our client trademark high clear, and the size PROSTIBAME is not confusingly similar to our client's trademark PROSPAN. And the second difficulty in this case is that the outer labels of high Xenial or PROSPAN products will not register as industrial design in Vietnam. So it's impossible to rely on the industrial designs rights to enforce against the suspected in this case, the suspected infringement in this case.
If it is not possible to rely on trademark rights or industrial design rights, what other options available to enforce against the suspected infringement?
As you know, under intellectual property laws of Vietnam, the goods packaging may serve as commercial indications. The owner of such commercial indication may enforce against the packaging, the goods packaging of others if it meets two requirements. Firstly, the adverse party goods packaging is regarded confusingly similar to the one of the IPR holder. And secondly, the IPR holder's good packaging has been used widely and stably in lawful business activities in Vietnam, and it gained certain reputation and known to the consumers. In this case, we advise our client to provide us with evidence to meeting unfair competition requirement, based on which we submitted petitions for handling the case under unfair competition legislation in Vietnam.
I understand that in order to take action under unfair competition legislation, the IPR holders must use their commercial indications stably and widely, and needs to provide a lot of documents to prove that. How if the IPR holder just launched their product in the market for a short time, then they appear products of the competitors with similar packagings?
I think it's a very good question. You cannot prove that your goods packaging or commercial indication have been widely or stably used in the market if you have just launched their products in the market for a short time. As far as I know, not a few illicit traders in Vietnam monitor the products of reputable companies in the market, and right after the reputable manufacturer market their products, there appears immediately the products without a packaging very similar to the goods packagings of the reputable manufacturers. In such a case, it may not be possible to enforce against the suspected infringement under unfair competition legislation because the IPR holder cannot provide sufficient evidence on the wide use of their commercial indication in Vietnam. The best option, in my opinion, in this case is to immediately register the goods packagings in form of works of applied art or copyright with the Copyright Office of Vietnam. In various situations, a copyright registration certificate issued by the Copyright Office of Vietnam may assist the design or the trademark owners in enforcing against the suspected infringement in Vietnam. If the infringement is detected while the trademark or industrial design application is still pending at the IP Office of Vietnam.
So, how long the copyright registration in Vietnam take? It is expensive, and whether it is effective to enforce against infringers based on copyright?
It takes around 1 month from the filing date to obtain a copyright registration certificate in Vietnam, and it's not expensive to register a copyright. After obtaining a copyright registration certificate in Vietnam, you are the owner on records, and you may use this certificate to obtain assessment conclusion on copyright infringement from Expertise Center of Copyright and Related Rights, or we say briefly ECCR. According to our observation in recent times, the use of copyright to prevent trademark and the industrial design infringement in Vietnam is a new trend and tend to increase because it satisfies two requirements of the right holders. Firstly, speed, fastness, and secondly, efficiency comparable to enforcement based on trademark or industrial design rights. After ECCR was established in 2016 and began operation for the last 6 years, when an infringement is detected, the rights holder can use the copyright registration certificate to request the ECCR to provide expert opinions or assessment conclusion on whether or not an infringement is being committed. And based on that basis, using administrative and or civil mechanism to fight against IPR infringement in Vietnam. Quite a few requests for assessment of copyright infringement have been filed with the ECCR, and in some locality, the market management authority have accepted to handle copyright infringement based on the ECCR assessment conclusion.
Oh, I agree with you that owning a certificate registrations in Vietnam may be powerful tool for brand owners to fight against tricky IPR infringement and theft. If you determine to base on trademark or industrial design rights, you need to have relevant certificate, which are only issued after a lengthy examination process. About 18 to 24 months for trademark and 8 to 12 months for industrial design. While it is not possible to provide evidence on wide use of your goods packaging in the market if you just launch your products in the market for short periods of time. Therefore, at this current stage, a time-efficient and fast IPR protection strategy, in our opinion, should be prioritizing unnecessary resources for copyright registration in addition to registration of trademark and industrial design, if applicable, as soon as possible, effectively, especially when the ECCR has carried out the assessment of copyright and will rely infringement upon the requirement of IPR holders and Vietnamese authorities.
KENFOX IP Law Office, one of the fastest growing patent law firms, provide the full range of IP services in Vietnam, Laos, Cambodia, Myanmar, and other Asian countries. In 2019, KENFOX was listed in the top 10 patent filer before the IP Office of Vietnam, or we say briefly, IP Vietnam. In 2020 and 2021, KENFOX was listed in the top 20 patent filer before IP Vietnam. In Laos, in respect of patent sectors, KENFOX was ranked by the Asia IP in the first tier of patent filers in 2019 and 2020, while in the first tier in trademark filers in 2021. The firm was chosen to win the Laos IP Firm of the Year in 2021 by Asia IP Award. Please contact KENFOX IP Law Office today if you are in need of a professional IP service provider to assist you in developing your business in the right direction.